Let's talk now about what your legal rights are when you buy a used car. There are probably a few people who actually enjoy shopping for a used car, like hobbyists, collectors, and certified car nuts. Some people just like shopping, and it hardly matters for what. Others like the challenge of finding a bargain or outsmarting someone. Most of us, though, dread the thought of shopping for a used car, and it's no wonder. Polls have shown that the majority of us put used car salespeople near the top of the list when it comes to being untrustworthy. And they're not alone. Even some private sellers can get pretty devious when they're trying to unload the family lemon.
Despite all this, far more used cars than new ones are sold each year. The number of available used cars is far larger than the number of new cars that you can buy. The most expensive car sales, as well as the least expensive, involve used vehicles. For some people, a used car is the only choice. For others, it's just the right choice, a way to get more car for the money. Don't let fear keep you from considering a used car instead of a new one. If you do your homework and shop sensibly, you'll have an excellent chance of getting good value from a used vehicle. Most used vehicles are sold privately, with one owner selling to another owner. Buying from private owners offers you the largest selection of cars and the greatest chance of obtaining a real bargain. It's easier to tell how a car has been used and cared for. On the other hand, you'll have to pay cash or arrange your own financing. You won't get a warranty, and you could even end up with a stolen car. New car dealers tend to have the newest and best used cars along with the highest prices. They usually offer warranties and always have financing, though it's usually cheaper to arrange your own. New car dealers tend to wholesale trade-ins that aren't in good condition. The dealers almost always fix minor mechanical problems and do routine appearance work on the cars they do sell. Used car dealers generally offer warranties and financing and are more likely than new car dealers to have older, less expensive vehicles for sale. You can be sure that some of them may be in less than top condition. Most used car dealers buy the majority of their cars from wholesalers, who in turn get them from new car dealers. Used cars are also available at government auctions and from fleet owners like the rental car companies. Don't purchase from either of these sources if you're faint-hearted or inexperienced. You have no recourse if the car isn't what it seems once you get it home.
When I bought my used car from the local dealer, he said it was in good working condition. But a week after I bought it, my car overheated 4 times. What should I do?
Well, if you were told that the car was in good working condition when you bought it, that's a warranty that the car will work properly. The dealer should repair the car as soon as possible. If he can't or doesn't properly repair your car, you might consider suing him for damages.
I'm thinking about buying a used car for my daughter to drive to school. Should I pay a mechanic to inspect the car before I buy it?
I think it's a very good idea. In most areas of the country, you'll find companies that will perform a thorough inspection for a fee of around $100. Most of these companies diagnose problems, but they don't perform any repairs. The advantage is they don't have a vested interest in finding faults that don't really exist. The fee they charge is usually pretty small in relation to the cost that you may encounter if you buy a used car that turns out to have major problems. Unless you are a trained mechanic, an inspection by a qualified neutral party is the way to go. And if the seller refuses to let you have the car inspected, you can be pretty sure you are looking at a car with a history of trouble. If you're buying from a private party, make sure the title has only the name of the seller on it and not a lender's. If you have the least suspicion that a car you're interested in purchasing might be stolen, get the vehicle identification number and have the police run a check on it. Also remember that a car that you buy from a private party is not covered by any implied warranty. If you wish to be protected from possible defects, make sure to have the seller write out and sign something specific that will cover your purchase. Wherever you get your used car, don't expect perfection. Even new cars aren't perfect, and all cars require more maintenance as they get older. Finally, don't be greedy. I've said it before, and I'll say it again. If a deal seems too good to be true, it probably is.
For many of us, insurance is the single biggest expense of owning a car. Unfortunately, we usually have far less control over the cost of insurance than we do over the cost of our vehicle. That's one reason why auto insurance is such a hot topic for state government.
Judge Wapner, I have to admit I'm confused about the different types of automobile insurance. Can you explain the differences between them? They're confusing.
You're right about that. Basically, automobile insurance can be grouped into three categories: liability, collision, and comprehensive coverage. Liability insurance protects the owner of a car from liability arising out of his negligent use of that car. In other words, liability insurance covers personal injuries or property damage that you cause to another. The second type of insurance is collision insurance. This is designed to cover damages to your car when it runs into something or is run into by another vehicle. Finally, comprehensive insurance protects your car from damage caused by something other than a collision. For example, collision insurance would cover fire, theft, and falling objects. First, let's talk about liability and no-fault insurance. The traditional auto insurance system is based on fault. In other words, the person who causes an accident pays for all the damage. To protect themselves from being wiped out financially after a serious accident, car owners long ago began purchasing liability insurance to defend themselves against lawsuits and to pay any damage that may be assessed against them. Once car ownership became common, pressure began to build to require drivers to carry liability insurance so that anyone injured through the negligence of another would be compensated. States began requiring insurance or proof of financial responsibility. This required drivers to prove that they had the ability to pay damages up to some arbitrary level. But once insurance was required, then the states had to figure out what to do with the bad drivers that no company wanted to insure and with those drivers who just couldn't afford insurance. To cover these drivers, states established assigned risk pools and parceled out the risks among all insurers in proportion to the amount of business they did in the state. What this did was to drive up costs for everyone. Meanwhile, insurance costs were driven up even more by litigation over who was at fault in accidents. The worse the accident, the more it paid to contest liability. Since in most two-car accidents, both drivers are at fault to some degree, and the facts are seldom clear, the fault system made for considerable uncertainty about when or if an injured person would recover anything. Studies showed that only a small percentage of insurance premiums went to pay claims, while a great deal went to pay for litigation. Beginning about 1965, proposals were introduced to abolish the fault system and replace it with first-party or no-fault insurance. These changes made auto insurance more like medical or fire insurance. Under a no-fault system, drivers who aren't at fault must first seek compensation from their own insurance company. After they've done this, it's usually possible to sue the negligent driver for the remaining damages. About half the states now have some form of no-fault insurance, but most of the state insurance systems still give an injured party the right to sue in serious cases.
Judge Wapner, what happens if both drivers are at fault in an accident?
In the past, a driver that was partially at fault for an accident could not recover anything from the other driver. This rule was known as the contributory negligence rule. In recent years, courts and legislatures have come to believe that the contributory negligence rule is unfair. In many jurisdictions now, courts attempt to apportion the amount of damages based on the degree of fault of each driver. This is known as the comparative negligence rule. A driver who's only minimally to blame for an accident can usually recover most of the damages suffered. If, on the other hand, a driver is found to be 50% negligent for the accident, he will only be able to recover 50% of the damages.
How are insurance rates determined?
Insurance rates vary depending upon who you are, where you live, what your driving record is, and what kind of vehicle that you drive. Your liability rates are going to be higher if you have a record of prior accidents, especially if you were at fault, or if you've accumulated a lot of traffic tickets. Being young, being male, driving a powerful or racy model car, living in urban areas or high crime areas, all of these things will drive up your rates. You will also pay more for liability insurance if you live in a state where juries award more generous judgments to injured people. Most of these factors also apply to no-fault rates. The cost of collision and comprehensive coverage depends a great deal on the value of your car. Most companies won't give collision coverage on vehicles which are older than 7 years. Another type of insurance is uninsured motorist insurance. This provides coverage for accidents involving uninsured drivers. The cost of uninsured motorist insurance depends mostly on the number of uninsured motorists in your state, but it's usually inexpensive. Unless you're prepared to move or change cars, there isn't a great deal you can do to lower your premiums except shop. A higher deductible on your comprehensive and collision coverage will help a little, but if your car is financed, the lender will require you to maintain that coverage at a level high enough to cover the amount of your loan. According to the experts, the minimum amount of liability coverage isn't enough in most states. I personally recommend you carry limits of at least $200,000 to $400,000. Extra coverage beyond the minimum is quite inexpensive. If your limits are too low and you're found liable for a serious accident, you could be bankrupted by a judgment despite having insurance. However much it costs, I don't recommend owning a car without buying insurance, even if your state allows you to drive a car without it. If you can't afford the insurance, you really can't afford the car. Remember that more expensive cars generally cost more to insure. Keep that in mind when you're shopping for the car so you don't end up with a nasty surprise. If you already have insurance, your agent should be able to tell you how much your new premium will be if you buy a different car.
Let me introduce Paranoid Pete. Paranoid Pete is worried. His car needs service, but he can't decide where to take it. He's attracted by the white lab coats and large, clean facilities at the dealership, but the resemblance to a hospital extends to the computer-generated bill. Paranoid Pete can never seem to get out of the shop for under $200. It's hard for him to communicate with the people actually doing the work. What's worse, the mechanics never quite fix that annoying rattle or erratic electrical short. Now, Pete's heard good things about Precision Auto, a small independent shop, but his past experience with such places has been mixed. He lost tools from his trunk once. The mechanics always seem to leave grease on the steering wheel, and some of the people hanging around look kind of shady. Then there's Joe's Grub Gas and Garage. They're friendly, but they don't inspire confidence. Sometimes you wait a week or more for parts. Sometimes the mechanic takes the day off. Sometimes the cook who supplies the grub is called into the garage to work on the cars. What's more, they never call when they say they will. Pete's begun to believe that everyone is out to get him. What's Pete to do?
When it comes to auto repairs, many of us are like Paranoid Pete. We are aware of some of the trade-offs between convenience, security, and price, but we don't know enough to feel completely comfortable with our decisions. Fortunately, there are some easy ways to improve the odds of getting pretty good value for your money. Reliability is something that you have to consider when you buy a car, and it's just one factor manufacturers consider when they design one. Cars are getting more reliable even as they get more complex, thanks to technical advances. The downside is that they also cost more to buy and more to maintain, even though less regular service is required. With more choices, more specialization, and less frequent service needs, we're less likely to go to the same repair facility for years and years. Without that experience, we must rely on other people's opinions, appearances, ads, guarantees, and legal protections.
Price, convenience, features, reputation. The same factors are as important in choosing a repair facility as in choosing any other service or product. No one else will balance these factors quite the same way you do, but other people's opinions can help. Ask around, look around. If you shop carefully and match your needs to the repair facility, you shouldn't have any problems. The nature of the business makes some disputes inevitable, however, and a few places may be dishonest. Here are some legal rights you should be aware of. Your first legal right when dealing with an automotive repair shop is a written estimate.
Most states require written estimates and forbid charging more than the estimate without further authorization from you. If the diagnosis requires tearing down your car's engine or transmission, be sure you're clear about what it will cost to put things back together if you decide you don't want to go ahead with repairs. Never sign a blank work order.
Judge Wapner, I took my car to an auto repair shop and was told that the cost of repairs would be $500. When I went to pick up the car, the actual bill came to over $1,500. That's $1,000 over their estimate. Am I required to pay the bill?
If the estimate was in writing, you're only legally obligated to pay the amount of the estimate. If you didn't get the estimate in writing, then you may be legally responsible for the amount of the bill. If your mechanic wants to charge you a great deal more than the original estimate, you may be the victim of a type of fraud called lowballing. This is a practice whereby a mechanic quotes you an extremely low estimate so that you will be persuaded to authorize repairs. Whether or not you have a written estimate, the easiest course of action is to pay the inflated repair bill, get your car, and sue the mechanic for fraud in small claims court. If you make a solid presentation and have your evidence ready, there's a good chance the judge will agree with you. Another point I want to make here is always get at least 2 estimates in writing. You never know when the first repair shop may be overcharging you. Shop around.
Your second legal right when dealing with an auto mechanic is to have access to your car's replaced parts.
You should look at, or preferably take back, your replaced parts. The law in most states requires that they be offered to you. Have a mechanic at another shop check them. If you suspect that the parts didn't come off your car or didn't need replacing in the first place.
Your third legal right is that you receive the service promised by warranty.
The shop or dealer offering the warranty is responsible for living up to its terms. Make sure a repair shop guarantees its work and parts for a certain period of time. If they don't want to give you a written warranty, think about taking your business elsewhere. Never hesitate to take the car back if there's a problem. Don't accept inferior work. If the car isn't fixed the first time, take it back. But if the shop can't seem to fix the problem after 2 or 3 tries, then by all means take the car to another shop. If you incur extra costs because the first mechanic was incompetent or negligent, you can usually file suit in small claims court to recover any extra amount that you have to spend.
Another legal right you should be aware of is the mechanic's lien.
The mechanic's lien protects the shop that does work on your car. With rare exceptions, you'll have to pay the amount the repair shop says you owe if you're going to get your car back. If there's a dispute, it's usually necessary to pay the whole amount and then sue in small claims court for a refund. Don't think that you can just write a check and then stop payment on it. This is where the mechanic's lien comes into play. If you don't pay for the service, the mechanic then has the legal right to have your car towed and keep it until you do pay. You'll probably end up paying for the towing and storage as well. If you have a problem with your mechanic, by all means call your lawyer for advice before you do anything that will make the situation worse.
Judge Wapner, I hit a large pothole on the street which caused $350 of front alignment damage to my car. Can the city be held responsible for the damages?
This would depend. If the pothole was dangerously wide and deep, and if the city was aware, or should have been aware, that this was a dangerous condition, the city would have to pay for the damages. It is the city's responsibility to be aware of the condition of its streets and to keep them reasonably safe.
Finally, let's talk about purchasing a new car. There are several legal aspects of this purchase that you should be aware of to protect yourself, like financing.
New car dealers like to sell cars, but they also like to finance the cars they sell since they profit from originating the loan. Dealers today often have loans available from several sources. Such loans can be fully competitive, and it certainly saves time and trouble to get your loan when you order your car. Be forewarned, however, that to get a fair loan, you have to have done your homework before you sit down with a salesperson at the dealership. Before you even start looking at cars, check with your bank or credit union and find out what they're offering in the way of financing. Make a few calls to other lenders. Then check the automotive section of your local newspaper and see if they publish compiled data on certain auto loan rates. Actually, for anyone who doesn't pay cash, the cost of credit is just as important to your purchase as the cost of the car. If the car you want isn't on the lot, you may want to order it. Dealers usually try hard to sell the cars they have in stock, and they'll often give you a better deal on these than on one you order, but not always. For example, if a particular model is in short supply, the dealer may be reluctant to part with it, even though it's already on the lot, because then they won't have a demonstrator. If the dealer does decide to sell it, you'll probably be asked to pay a premium price. Keep in mind that the amount of the car's sticker is only a suggested selling price. While dealers will usually sell most cars below sticker, they can legally ask for and probably get more. If you do order a car, be sure you understand the contract and that the terms are what you want. Normally, the contract commits you to accepting the car you order when it comes in, provided that it has the right options, is the right color, and has the specified equipment. If you reject a car that matches your order, you may lose your deposit. That's the law. If you change your mind after you place your order, dealers will sometimes refund a deposit or credit it toward another car, but they don't have to unless the contract says so. Any contract you sign should specify a firm price and a delivery date. The dealership will usually protect itself from unforeseen price increases from the factory by specifying in the contract that these increases will be passed on to you. Look carefully at these clauses to make sure that the dealer won't make additional profit from them. These and other clauses are certainly negotiable. If a model is in short supply, dealers sometimes create a waiting list and ask for a small deposit. However, if your car isn't delivered by the date specified, you should get your deposit back. My advice is not to buy a car in this situation, but if you must, at least understand what you're doing. Actually, you don't order a car when you pay a deposit. You simply reserve a place on a waiting list. When a car comes in, the people on the list are contacted in order and offered the car at a price set by the dealer. The first one who accepts the deal gets the car. Before you put your name on a waiting list, make sure you can get off the list and get your deposit back at any time that you desire.
Because of the tax advantages, it's long been popular for businesses to lease cars. Now it's becoming increasingly popular for individuals, especially for those who drive expensive prestige cars. If you decide to lease a car instead of buying one, there are legal ramifications that you should be aware of.
Leasing makes sense if you trade cars often. It's generally cheaper per month to lease a car than to buy it, but you have to give back the car at the end of the lease. It's like renting a house versus buying one. If the market is normal, it's cheaper per month to rent. While you don't build equity, you also don't have to make a big down payment. Some leases may give you the option to buy at the end of the lease term. The option to buy may be at a preset price or may be at a variable price depending on how much the car is worth at the end of the term. Entering into a lease is like entering into another contract. You should check the terms of the agreement before you sign it. Let me end this discussion by talking about your recourse under the law if you have a car that doesn't perform up to predetermined standards. All but a handful of states now have what are known as lemon laws. A lemon law provides relief for the buyer of a new car that the dealer is unable to repair satisfactorily. The laws usually apply to private purchasers of new cars for personal or non-business use. While the exact details of these laws vary from state to state, they usually provide that if the dealer is unable to repair the vehicle after a certain number of tries, or the car is out of service for a certain number of days, arbitration is available to determine whether the manufacturer must provide a refund or a replacement.
My brand new car has been in the repair shop 4 times since I bought it 8 months ago, and it's still not running properly. What can I do?
First, make sure you keep accurate, detailed records of everything that's wrong with the car, along with what has or hasn't been fixed properly. Second, report the defect to the Auto Safety Hotline. You can get their toll-free number by calling 800-INFORMATION at 1-800-555-1212. If enough people have complained about the same problem, the manufacturer may have to issue a recall for that model and fix the defect. Third, notify the manufacturer about the problem. Do this in writing and send it by registered mail so that you have a record. Fourth, if the problem still isn't fixed, submit a complaint in the manner described in the manufacturer's warranty in your owner's manual. This will set in motion the arbitration process in which the manufacturer will try to resolve your problem without you having to go to court. Keep in mind that some states, including Massachusetts and New York, have their own arbitration panels. You should check with your state attorney general's office about the laws in your area. Finally, if you aren't pleased with the arbitration panel's decision, consult a lawyer about further action. In many instances, if you win your case, the manufacturer will be made to pay your legal costs.
My new car turned out to be a lemon. Can I withhold payments on the new car loan?
If you arrange a loan with a lending institution, such as a bank, you may not withhold payments. The loan is between you and the bank's entitled to repayment regardless of the condition of your car. If you finance the car through your car dealer, you may be able to withhold payments. Consult an attorney for advice in this situation. In most states, you can't invoke the lemon laws unless the defect can't be repaired and is one that substantially affects the car's safety or value or your ability to drive it. So if you've got a rattle that won't go away, but it doesn't keep you from driving the car, you probably won't be able to demand arbitration. And if you lease your car, you won't be able to invoke the lemon laws at all, since you aren't the car's owner. The leasing company is.
Lemon laws are a supplement to the manufacturer's warranty and the federal law on warranties, both of which Judge Wapner talks about in detail on Tape 8, Side B, which is called Your Rights as a Consumer. Please keep in mind that the general information provided on this cassette is not a substitute for legal advice from a lawyer. For specific advice based on your own individual circumstances, see the lawyer of your choice. You may want to listen to the tape on You and Your Lawyer to help you in selecting and working with an attorney.